Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Leslie Bowe, a Missouri and Kansas construction lien law guru. Today's webinar's topic is Don't Sign a Waiver or Release Without Reading. So without further ado, I'd like to introduce the fabulous Leslie Bowe.
Thank you, Rachel. I am so happy to be here today to talk about this topic. As a construction lawyer, waivers, lien waivers and releases are one of the more litigated issues. So I appreciate the opportunity to do some upfront education so that we can all have an understanding of what these documents that are used so commonly in the construction industry need to look like, so that you're not waiving lien rights or bond claim rights down the road. So I appreciate the opportunity to be here, and we will jump right in. Oh, for the purposes of the webinar, if you have any questions, please just type them in the chat box on the right, and we will get to those questions at the end. Don't include your name or company names in your questions, just list your question, and we will address that at the end of the webinar. And with that, we'll go ahead and get started. As we know, today we're here talking about lien waivers and releases. So for the purposes of this short webinar, I'm not going to go into the background of what a lien waiver, what a lien is, or what a bond is, bond claim is, because we just don't have time for that today. And we've had other webinars on those topics. So feel free to research on the same place you found this one, and you should be able to get some background on those things. For now, though, we're just going to assume you know what a lien is and a bond claim is, and we're going to talk about the documents you need to make sure are read appropriately before you sign them. So first off, we'll talk about what is the difference between a lien waiver and a lien release. I like to explain the difference between these because so commonly the terms are used interchangeably. Out in the construction industry, in the world, out in the real world, you may hear them used interchangeably or together. And even us lawyers will use the terms together because we do know they're used interchangeably out in the world, and so we want to cover all the bases. But technically, so that we know, a lien waiver is something you're signing in advance of actually filing a lien that would waive your right to file a lien. And a lien release is something that you would sign and file after you already had a lien on file that would then release it. That way, when someone searches the title on that property, yes, they'll see the lien showed up, but they'll also see there was a release as well, and you won't be getting calls down the road about your lien on file. So those are the difference between the two terms. Today, I'll mostly talk about waivers, and I'll mostly probably use the term lien, but these things apply to bond claims as well. To start off, I think it helps everyone understand how important the lien waivers are if we just briefly talk about the payment process and how they're used in the industry. So this is, I'm sure, familiar information, but I think it really does bring home why it's important that the documents we're signing need to be scrutinized very carefully. So as we all know, the typical payment process is that a progress payment will be due from the owner to the general contractor. In order to get that payment, the general contractor is going to require all the subs and suppliers to sign a partial lien waiver, and the general contractor will in turn furnish that, all the subs and suppliers lien waivers along with its own as a part of its payment application to get payment. And upon receipt, the owner or maybe a lender or an agent or title company will then review those documents, make sure they're in order, and make sure they do have lien waivers for what they're getting ready to pay out, and that it's only at that time they'll make a progress payment. And then, of course, the subs and suppliers then in turn would get paid. So I like to highlight this because a lot of people look at lien waivers, especially partial lien waivers, as just another document they're signing to get their payment application in, and they believe they know what it means, but there's a lot of language out there that can obviously limit your lien rights in the future, and that's why we're talking about it. One really important thing to understand here is that fourth step there, that the owner or its agent, whether it's a lender or a title company, is going to review those documents and make the progress payment. That is why it's so important to read the language of your lien waiver, because there will be third parties relying on what you've signed in order to release payments. And it's that reliance that courts will often rely upon when they're enforcing perhaps a very harsh result on someone who signed a lien waiver and signed away their lien rights. They're going to say, we're sorry, but you signed this and somebody else relied on it in changing their position in releasing funds, and so we're going to hold you to it. So you'll recall I mentioned there's what we were talking about there in the payment process is a partial lien waiver. So there's basically two kinds, a partial waiver and then a final waiver. And partial are the ones you're going to be signing all along in exchange for a progress payment. And then a final lien waiver, so oftentimes will have some more language in it than a partial does. And that will be in exchange for a final payment. And you'll be waiving all of your lien or bond rights on a project when you sign that one. And both of these can have terms that could be harmful to you and harm your position. So you want to read them carefully. So within the lien waivers, there's two ways that we typically quantify what they're covering or limit what they're covering. So we'll see a lot of time-based lien waivers, and then we'll also see amount-based lien waivers. So a time-based lien waiver is one that's going to waive all of your lien and bond claims as of a certain date. An amount-based lien waiver is one that will waive all of your lien and bond claims attributable to the amounts listed. As a lawyer, I prefer the amount-based lien waivers because we run into various types of problems with time-based lien waivers. Oftentimes, as you all know, that whole payment process we went through earlier takes time. So it's not, these days, unless it's a really small project, you're probably not getting cash or in exchange for a lien waiver that you're signing on the very same day. You're probably not even on a large project, if you're getting your payments auto pay or wired, you're still going to be signing your lien waiver prior to the day you get your payment. So the problems that occur with a time-based lien waiver is sometimes the date that you're waiving all of your lien rights through might be the date that the payment's actually made, or date of the check. Or even if it's the date that you sign it, you may be signing a lien waiver that's going in with a pay application, a week or two, time-wise, maybe signing it while you're still doing work. So let's say you've been working and your payment application is due on the 15th. So you're working, you get everything in on the 15th, but you're still working. And I don't think I'm articulating it correctly, but the time that you sign your lien waiver may be the date that you waived all your lien rights through, and it may not actually equate with what the money that you're getting and the pay application. Hopefully that makes sense. If not, you'll get my phone number and email at the end for anything I did not state very articulately. So those are the kind of problems we see with a time-based lien waiver. In light of that, I always would recommend, if you have the opportunity to do so, to limit yours to the amount that you're getting paid. So here's some typical lien waiver language that you might see. The undersigned waives all rights to file a mechanics lien or a bond claim against the property or any improvements for any labor and or material supplied. And this underlying language is something I really like to see, conditioned upon receipt of certain amount of money. The conditioned upon is important because we want the lien waiver to only go in effect if you actually get the money in your account. A lot of times lien waivers will say that you're already acknowledging receipt of the funds, but you're not getting the funds until much later. So we don't want that language. You want to cross out anything that said you're acknowledging receipt of funds unless you already have them. And we prefer that you write in instead as conditioned upon receipt of the funds. And then again, B represents that the lien waiver that's time-based. And it's not to say you can't sign a time-based lien waiver. It's just you have to be very careful that the date that it's effective is the date that matches up to all of the invoices or the work and the labor that you're getting paid for. So let's say you're putting together your lien, your payment package with a lien waiver, and all of your invoices go up through, the cost you've incurred through the 1st, and you're not signing it till the 15th. You want to state that it's only effective for work and material furnished through the 1st of the month. Okay, next up. So here's some types of problems that we could see with different types of lien waivers. So first up, I've listed here a contractual lien waiver. This is a lien waiver that might show up in your contract before you even start work, saying you'll never file a lien on the project. It won't say you'll never file a lien. It'll have some more articulate language than that. But there are contracts out there where a signator to the contract would waive their lien rights. We're lucky here in Kansas, that type of a lien waiver is not enforceable, but I always want to make sure all my Kansas contractors know about it, because if you're working in another state, it may be enforceable. So if you're like me and pretty close to the state line to Missouri, you're lucky. Missouri doesn't enforce those either, but other states do, and so be aware. It's also just important to be aware of this, because if it's in your contract and you didn't know it wasn't enforceable, you know, a general contractor could come to you and say, you've waived all your rights to file a lien, release this or else. And if you didn't know it's unenforceable, you might feel pressured to do so. So I like to cover it at least to make sure everybody knows what the situation here is in Kansas. Unconditional lien waiver. So you'll recall that in the previous slide we talked about it's important to have some language that the lien waiver is only effective and it's conditioned upon receipt of the funds. And I already explained, we definitely don't want to sign something that says we're acknowledging receipt of payment if you haven't actually got it in your hands or in your bank account. Another thing to be aware of is what I call a lien plus waiver. You want to make sure that the waiver you're signing is only waiving lien rights and bond claims, not any and all claims that you may have. There may be claims that you're not aware of yet. You really want to make sure you're limiting it to purposefully and to limit to just what you're actually intending to waive, and that's a lien right or a bond claim on the labor and material furnished that you're getting paid for. Then another thing to watch out for are indemnification clauses. So this is a sample one here below that the signer agrees to indemnify and hold the lender and owner harmless from any and all liens or claims made against them or the property for the labor and materials. Now, this may be perfectly appropriate if all the other terms of your lien waiver are limited, as we've already discussed. But if you have any other problems popping up in any of the language, and then somebody goes and files, one of your subs or suppliers files a lien, or you yourself want to file a lien, not only have you waived your lien right, but you've agreed to indemnify and therefore, you know, basically defend and cover any costs that the owner or the lender may have associated with defending those lien claims that you signed a waiver for. So that's something to watch out for. Again, may be perfectly appropriate if you're 100% sure all the language of your lien waiver is technically correct. So another problem that we see come up with lien waivers is ones that appear on the back of checks. So this is some sample language I pulled off of a check. By endorsement hereon, the undersigned hereby acknowledges payment in full and does release and waive any and all right and claim against the maker and the real property described by the address on the voucher attached to the check on account of equipment or material furnished or labor performed to date in relation to the said property. So you'll see a couple problems we've already talked about here. This is going to be waiving lien rights up to the date, that'll be the date of the check. It also acknowledges payment in full. And if this is just another situation that if you're getting payment and you've still been working, let's say the check comes a month later and you've got a month full of work that this isn't paying for done, there's a concern that it would be waiving any and all lien rights up to the date of that check. Also, a real big problem that I find with lien waivers on checks is a lot of times people are opening the mail and signing checks and depositing them that don't know anything about what's going on in the project. So they may not be aware that there's outstanding change orders that are not approved yet, or there's a claim for, you know, maybe the whole project's a total mess and you've got some outstanding claims, delay claims or something like that that hasn't been approved. So if someone who isn't aware of what's going on in the project signs a check that has an endorsement, that's binding to the company that they've waived the lien rights. So it's real important to educate both your actual project staff about what's happening, but also your office staff and accounts receivable to be on the lookout for something like a lien waiver on the back of the check. It's very common to put them there. And, you know, one of the things that I talked about early on was how it can be a harsh result when a lien claimant gets their lien kicked because of a lien waiver they signed. You know, a lot of times it's the only way someone will get paid. And the other seminars that talk about what a valuable tool in your toolbox a lien claim is in helping you get paid really drives that home. So if you've waived your lien rights, it may be the only way you were ever going to get paid on that project. And courts do enforce them. And like I said before, it's really because other people are relying on it, the lien waivers that you sign, in order to change their fiscal position by issuing payment. So now that I'm sure you've heard all the bad news, I'll talk a little bit about what you can do to make sure that you are preserving your lien rights in your lien claims. So if the language of the lien waiver that you've been asked to sign sounds sketchy, if you see any of those terms that we've talked about here today, I would always encourage someone to reach out to a lawyer and have them look at it before you sign it. Sometimes people are afraid of you know, a big attorney's fee bill or something, but really a little bit of time with a lawyer to review the contract or the waiver that you're getting ready to sign can obviously save you big in the long run if you end up needing to enforce a lien claim in order to get paid on a project. So here's some language that I've got put together that you could technically maybe amend your contract with it to say any release or waiver that the subcontractor or supplier ever signs would only do these things, or you can tack this into an actual lien waiver at the bottom. And this would say this release or waiver shall apply only to work or material furnished for which payment has been received in full, shall not apply to retention, unbilled changes, claims that have been asserted in writing, or claims that have not yet become known to the subcontractor or supplier. And then there's our conditional language, and shall be conditional upon receipt of funds to the subcontractor's or supplier's account. This language would do all of these things that we've been talking about. It would preserve your claim for unbilled changes or claims. Oftentimes, I would suggest being as specific as possible. So if you know there's, you know, pay or change order requests number 4 and 5 that have not been processed or approved, I would put those in there, and I would say, you know, specifically change orders 4 and 5 and any other unbilled changes, so that you're very clear that you're not waiving that specific right. Sometimes people feel like a form is, you can't write on it or change it, you're just supposed to sign it and return it, but we have clients write in limiting terms or conditions like this all the time on lien waivers before they sign them, and that's what will save you. So that's pretty much all I have for today. If anybody has any questions, Rachel, do you see any questions in the chat?
Let's see here. I do not see any questions that have come through. However, if anyone is on this webinar and you think of a question after the webinar is over, please feel free to reach out to myself or Leslie, and we will make sure to answer any questions that you guys have. I'd like to say thank you so much, Leslie, for your time today and educating us on this very important topic. You really did provide us with super helpful and extremely valuable information. Lien waivers can be super tricky. Now let's see, if you guys would like to take a moment to review us on Google, we would appreciate that. And then if you go to the next slide, I want to talk about our next webinar with Leslie. So the next webinar will be on Wednesday, October 25th from 11:30 a.m. to 11:50. The title of this next webinar will be Getting Paid Faster with Liens, Bonds, and Contracts. So go ahead and register at sunraynotice.com/education. And that's all that we have for you today. Thank you again, Leslie, so much. And I hope everyone has a sunny day. We hope to see you on our next webinar.